Okay.
You've been here before, correct?
Yeah, I've been here before.
And you filed some kind of motion. Have you filed anything?
What's that?
Have you made any kind of filings on your behalf?
Yeah, quite a few.
This is the city of Detroit versus Jamil Amir Lockhart, case number
SP 121-8061, SP 121-8072, counts 1 and 2, SP 124-78, strike that, SP 124-7989, count 1, 2, and 3, and SX 378-296.
Oh, go ahead.
Yeah, so I am Jamil of the family Lockhart. The motions that I filed and the documents that I have filed have all been trying to ascertain the jurisdiction of this court. And I don't understand the nature and cause of the action against me. And I'm trying to understand under what jurisdiction the court intends to proceed. First of all, is this going to be a civil or a criminal action? Criminal. Okay.
Misdemeanors punishable by 93 days in jail, up to maximum possible penalty, 93 days in jail, and $500 in fine for each of the misdemeanor counts.
Okay. So, Your Honor, the Constitution grants this court.
Hold on. Listen, Mr. Sanchez, you have to be quiet, sir. Go ahead, sir.
Okay, Your Honor, the Constitution grants this court two criminal jurisdictions. One is criminal jurisdiction under the common law, and one is a criminal jurisdiction under admiralty or military tribunal. From Article 1, Section 8, Clause 17 of the Constitution. So in which of these two criminal jurisdictions does the court intend?
Sir, this is something, where is your motion, sir?
There's a motion filed there. It's a motion to dismiss based on lack of subject matter jurisdiction.
All right, I'm going to deny that motion. I'm going to set a bench trial or jury trial if you choose. Which one would you want to have?
Okay, Your Honor, under what grounds, what facts and findings and conclusions of law are you denying that motion to dismiss? I'm trying to understand the jurisdiction of the court. You have not disclosed it to me. I'm asking you
to disclose it to you. Check the court rules, sir.
Well, Your Honor, the Sixth Amendment grants me the right to understand the nature and cause of any action brought against me, and it grants you the duty to inform me. So I don't think you would be breaching your oath of office if you were to inform me under which jurisdiction this court intends to proceed. In order for me to intelligently defend myself without an attorney, I need to understand.
This is the classic collision you see in these cases. He's not arguing the facts, he's arguing the frame. What jurisdiction are you in? It sounds powerful, it feels constitutional, but courts run on procedure. When your opening move challenges the court's right to exist, you start at war, not in defense.
Sir, the Sixth Amendment grants you to inform me of the nature and cause of any action brought against me. And right now, you are denying that right.
I'm going to tell you, sir, don't speak over me. You want me to inform you of the nature and cause of the action. You're charged with driving. Drive while license not valid or improper on 7/3/2020, run around 4:29 p.m. in the area of Jefferson and St. Albans in the city of Detroit. That's punishable by 93 days in jail and or $500 in fines. The other charges, no insurance misdemeanor. On the same date and time, you were operating, the allegation says you were operating a vehicle in that area, of which is a 2011 Jaguar in the city of Detroit. and could not provide or did not have the necessary insurance required on that motor vehicle, that punishable by 93 days in jail and or $500 in fine. On 9/11/2021 at 2:57 p.m. or thereabouts in the area of Jefferson and Riopelle, you are the allegation is that you were driving the same 2011 Jaguar in the city of Detroit without the proper registration on that vehicle, that punishable by 93 days in jail and or $500.
Sir, I understand
the maximum possible. Don't interrupt me, sir. On the same date, 9/11/2021, around 2:57, same date time, it is alleged that you were driving in that area in the city of Detroit, in Jefferson and Riopelle. You're driving of that 2011 Jaguar without a valid driver's license. You drove while licensed.
Notice what just happened. The judge does inform him of the nature and cause, specific charges, dates, penalties. That's the legal floor. You can fight the evidence, you can challenge the complaint, but the Sixth Amendment box just got checked on the record. From here, if you keep arguing, what ocean are we sailing on? You look like you're dodging the case, not defending it.
This road, son, young man. Do you want a bench trial?
So I cannot. I'm asking you a very specific question, and it is this a criminal jurisdiction under common law, or is it a criminal jurisdiction under military tribunal?
Listen, it's let's move on to the next person.
Sir, please answer that.
It
can only be one or the other.
You'll leave me no choice but to hold you in contempt. I'm asking you a specific question.
I do not wish to be held in contempt. I am trying to exercise my Sixth Amendment right. I can show you Constitution is exercise of a constitutional right cannot be converted into a crime, sir.
Sir, the way you speak to the court is via motion, okay? If you have a motion that I've already denied one of your motions, if you have another motion presented
under what basis, under what grounds have you denied my motions?
It's not my job to explain to you all of the court rules. So
there's only two jurisdictions which this court can operate under.
Just like any other, you're going to be treated just like any other lawyer that comes in this courtroom. Okay? So you have to know the rules.
Yeah, so I'm not trying to seek legal advice or ask you what the rules are. I'm asking you a very specific question. There can only be two jurisdictions under criminal law. And is it under common law or is it
common law or admiralty? This is Sovereign Citizen Doctrine 101. In real courtrooms, that fork doesn't open a secret door. It opens the contempt trap. The judge is signaling. File motions, use rules, stop debating metaphysics during scheduling. When warnings start, you're one interruption away from a new problem you didn't arrive with.
Hold that dismissal motion in abeyance until the date of trial. If there's no signed complaint on the date of trial, then we will dismiss by no signed complaint. So I'll give the city an opportunity to come up with a signed complaint.
I'm sorry, is the city the injured party here? Okay, well, sir, I move that we either dismiss this case or move this case to federal court. If the city is the plaintiff or injured party, they cannot also be the judge and prosecutor.
File a motion on that, sir. If you're saying that I do have a signed complaint for SP 1218072 counts 1 and counts 2. I do have a signed complaint for SX 3782961.
Okay, well, that brings me back to my original question. Is this a statutory proceeding? Because if there is, there would have to be an international contract or agreement. And I would implore the prosecution to put that agreement on the record and explain how I am party to it.
He pivots to show me the contract. Traffic cases don't hinge on international contracts. They're statutory offenses enforced by the state. If you want to win here, you attack the complaint's sufficiency, officer testimony, service, or proofs. not imaginary treaties. The judge again says, write it, file it, cite it.
In federal court, as I stated, if the city is the injured party,
File a motion so I can, on your removal motion. File a motion. I'm gonna give you a date. I'm gonna give you a date where that motion is gonna have to be due. I will entertain that. I'll give the people a date on their response if they choose to respond. And on another date, I will rule on that motion on the final pretrial date. So right now, I'm gonna set
Sir,
dates for you.
I do not wish to continue or delay this any further. There's been no evidence presented to substantiate any kind of jurisdiction in this case. This is our second time. I've asked for this the first time, and there's been no evidence of any jurisdiction. And I don't understand why on moving to another court date, and we have not addressed this very basic and fundamental issue of jurisdiction. If it cannot be proven and proven on the record, then this case must be dismissed. Well, I mean, I don't understand why we are delaying this any further.
We don't have to delay it any further. I can put a warrant out for your arrest and you.
Here's the second danger zone, refusing to return. The system has a built-in response, warrants. It's not personal, it's machinery. When you escalate to ultimatums, the machine answers with a lever you can't negotiate with.
Since of my understanding of the nature and cause of the action against me. So did you receive the documents that I sent you asking for your anti-bribery statement? Hello. Okay.
I'm gonna order you to report to the Wayne County Jail today.
I do not accept. I do not understand the nature and cause of the action against me. You have told me this is a criminal jurisdiction.
Sir, please don't. I told you don't say. I'm gonna ask some more days if you keep on talking. You already got 30 days.
I don't understand, sir.
I'm adding more if you keep on talking. Please do not say anything else. It says here, after the court determines whether criminal or civil contempt proceedings are appropriate, the court must determine whether the contempt was direct or indirect. If the contempt was committed during its sitting and in the immediate view and presence of the court, the contempt is direct, and the court may summarily make a finding of contempt and punish the contemptor. So I'm determining that this is criminal intent, the contempt. I am determining that it was done during the sitting of the court. We're on the record now. I've asked the young man, Mr. Jamil Lockhart, or as he has on here, Jamil of the family, continually not interrupt. I asked, the court is trying to set dates so that Mr. Lockhart's motions, if he wants to, or any of his pleadings could be preserved in writing so that the court can review those writings, give the opportunity for the city attorney, if he chooses to respond, and then the court on the final pretrial date, which I never got a chance to give out, would make a ruling on those. I continually asked Mr. Lockhart to not interrupt the court. I asked Mr. Lockhart, and I've exercised the utmost restraint, in my opinion, with Mr. Lockhart, and telling him that we will have no further conversation about the matter. And the only way that we can speak with the court is through motions. I'm not saying that Mr. Lockhart cannot speak. I'm saying that Mr. Lockhart must speak through the court through motions, and he refused to exercise restraint in his own self, follow the court rules, and he refused to obey the order of the court, which was to please not say anything further regarding the matter. He continually.
I'm sorry, Your Honor. It happened very fast.
It's happening again right now on the record. It's happening again right now on the record. So those are the reasons
I'm just
that I
apologizing.
find, again, another contempt. And it just continues to happen. And I'm gonna, now, if you have one more interruption with me, sir, I'm gonna add another 30 days to that. And you're looking at 60 days, you're gonna get 30 days Right now, you're gonna get 60 days if you have one more interruption to me. And it will be no early release, okay? And, so, those are the reasons. The court finds that the contempt was, and that therefore the contempt was direct. So, the court rules and statute and law gives me, the ability to summarily make a finding of contempt and punish the contempt.
This is the fulcrum. The judge explicitly explains direct criminal contempt, done in court's presence, summarily punishable. Whether you love this power or hate it, it's real. And once the bench says, one more interruption equals more days, every syllable you add is rolling dice with your freedom.
To interrupt its proceedings or impair the respect due to its authority. It's going to be ordered that you report today by 5 p.m. to the Wayne County Jail. And I'm ordering that you do 30 days in the Wayne County Jail. You have a right to appeal this order, and I gave you the dates that the next court hearing will be had for motions due, responses due, the jury trial date, and the final pretrial date. Sir, do you have
30 days. And look how fast it happens. Because contempt is about courtroom control, not the underlying traffic counts. A day that could have been motions and dates becomes immediate custody because the process became the fight.
Well, I try to do everything in accordance with the law. As you can see, I have filed documents. I filed motions. I've requested information, all in a desperate effort to wrap my head around the proceedings and what's going on here today. And I'm sorry if I may have gotten frustrated and not being able to understand the nature and cause and action against me. But just again, that was not my intention. I look forward to handling this as amicably as possible. I think that the record will show, I think that the prosecutor will agree that there is no international contract to which I'm tied under statutory jurisdiction. And I would love to see it. I would love to see that evidence. But also, we covered the fact that the city is the injured. This would be an improper venue anyway, but I appreciate your advice on handling that and moving forward with motions. I will be doing that. But again, this thing of contempt, it's just, as one man to another, trying to understand and stand on my constitutional rights and exercising them. And I feel today, as what's happened is my pursuit in doing that has somehow been converted into crime against me, which is a tragedy.
His apology is human and honestly tough to watch. He feels like asserting rights became a crime. But here's the lesson. Rights live inside procedure. File it, brief it, cite it. When you argue the universe instead of the docket, you lose the judge, then you lose the room. And then, today, you lose a month.